Good afternoon. My name is Ronaldo Hill, the chairperson designee of the New York City Loft Board. Welcome to our February 21st, 2019 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the Loft Board. The board is charged with overseeing the conversion of interior multi-dwelling buildings from commercial and manufactured spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. I just want to say for the record that we apologize for the late start. We were debating cases. We first turn our attention to a vote of the minutes from the January 17, 2019 public meeting. Are there any corrections or comments to the meeting? To the minutes. Mr. Delaney.
Forgive me, I got problems. Yeah, first, reading the minutes, I'm reminded that I've offered a sense of comments as to how to make the 2018 year-end presentation a little spiffier for public consumption, and I have not done that yet, but I will. I was going to ask you about the PSA report on 18th Street, but I see we've received that. On the bottom of page 9, through page 9, in the minutes we discussed the project guidelines, and there was some agreement that you were going to try to put together a distillation of for the layperson what's in the project guidelines. I just wondered what the status of that was.
Honestly, I have not gotten to it.
I started by telling you I haven't given you my comments. But it's on the radar.
Yes.
Okay, that's all. That's something. Sorry. On page 10, you reported on 2 cases, court decisions where we hadn't gotten written versions. Have those come in?
No, those were decisions from the bench where there's a transcript, and no, we haven't gotten the transcripts yet, but I will follow up the letter.
But we do expect in the court's own time, we will get some kind of transcript.
Yes, but it won't be a written decision.
Yes, I understand.
Yeah.
I understand. But when, and you'll forward those? When
Yes.
We seem to have taken a new tack, which I thought was perfectly valid, where on page 11 in the summary calendar cases, we have a 1 or 2 sentence summary of the decision. So, for example, access application, tenant provided access. Owner registered tenant is PO. You look at me like you haven't read the minutes, or I'm hallucinating?
I've read the minutes, but I don't recall seeing that. I'm not sure where that came from.
Yeah. T claims
Those are my notes. I have an annotated copy of the agenda, and those are my notes.
I found them on Google.
Huh?
I found them on Google. No.
No, they should not be there. Do
Okay.
you want them there?
I thought it was kind of nice, to tell you the truth.
I don't know. No, the decisions speak for themselves. I'm sorry. We will change those.
Because then the follow-up to that question.
I don't know how they got in there. Maybe I just said the wrong thing. I don't know.
Somebody didn't read the minutes.
It is totally possible.
But then we get to the master calendar cases, where now there's no summary whatsoever. So for
Which has always,
So Mr. Clark will present the case.
Mr. Clark presented the case.
Mr. Hilton thanked Mr. Clark.
Yeah.
So there's no summary in the minutes.
There never has been for the master cases.
But seeing what happened miraculously in the summary
But that
calendar,
was a mistake, that was a mistake.
I did not know that. So there's
Now he's spoiled.
I'm sorry, Mr. Bobbitt.
Okay.
That we made a mistake.
I'm sorry, I'm having a very rough day this morning. I apologize.
Believe me, I thought that was a softball, but, all right, so,
We will change the minutes and take out the descriptions in the summary cases, they should not be
Anyone
there.
else have that? I guess it was, right?
I guess it was. I don't have a copy of the minutes in front of me.
you all need a copy?
No, it's okay. It's okay.
Okay. And lastly, on page 17, at the top, second paragraph, the chair is quoted as saying, each attorney will present a 3 5-minute statement. I think you meant 3 to 5 minute.
It says 35?
It says 3-5
Oh, yeah.
hyphen minute. So 3 5-minute.
Three to five.
Yeah, I think 3 to 5
Okay.
would make you sound, 3-5 sounds like you're a cop talking about a precinct.
We will change that.
All right.
Okay. So I guess we
Any
want to table.
other?
Want to table that for now and
think
then
we
we'll
should.
bring them back next time?
Can we just do that? We'll just table this, then vote on the minutes until it's revised and,
We're tabling the minutes?
yeah, table the vote. Okay.
Can I just, all well and good, but with regard to the master calendar case, if somebody's reading the minutes and they see such and such board member presented the case, and then the next comment is the chairman thanking them for presenting the case,
Right.
what would be the harm in providing a one-sentence summary?
Because the decision speaks for itself, and there shouldn't be other, it could be misinterpreted, it could be misconstrued, the decision speaks for itself, and we shouldn't have the text of the decision in, I mean, if you want to put the conclusions, I don't know, I mean,
Well, if I were somebody doing research and trying to use the minutes, if it's a coverage case,
right,
and I don't know from the minutes whether coverage was accepted or rejected, it means then you bloody well better go look up every single.
I'm sorry, isn't there a vote?
There's a vote, but there's no recitation of what the order is.
Yeah, so I mean, we'll have to go look at the orders. They have to go look at the orders, they're all available on the internet, and so they have to go look at the orders, or they can ask us for a copy, more than,
And of course, on the internet, they'd be easier to find if you had the order number, but we don't have the order number at this point in minutes.
yes, but you can look at the document, you can search the document number, it'll still pop up.
Okay. All right.
I guess I'm not quite following. Since it's on YouTube and we're trying to provide a written alternative, why not put the summary or the whatever it is that will put?
These are the board minutes, and if the board wants that, we'll do that. But the board has to say, we want that. If the majority of the people wants it, we'll do it, but I think you're just feeding lawsuits. More fodder for people that are suing us. That's my opinion, but if the board wants it, we'll do it.
Chuck,
Your position is just to make this part of the public record outside of just our review of these minutes? Is that why you're,
Maybe I've been spoiled by the high quality of the minutes of late, but you kind of get to this juncture where somebody presented the case and then the next information is Ronaldo thanks them, but they're kind of, it does beg like what was presented. So I think I understand your concern that it could be fodder for lawsuits, although it would seem to me that if written in a very terse way, so we could at least know whether the order that was voted on was to accept or deny something, it would help a researcher who then might say, oh, I don't have to go look at that case.
What are you asking that at the beginning?
Sure. So here's a sample.
so let me ask you another question. Before I came on board, what were the minutes like?
Oh, they've been all over the place.
In the first number of years? Because remember when we were sitting here, those minutes were like 1 or 2 pages. We were a little concerned about the lack of information, which I absolutely agree that these are a whole lot better. And I don't know, not that I necessarily disagree with you, but it's just that we seem to get more and more bogged down with language.
Can I suggest that we put in the conclusions of the orders?
Yeah.
I think that's fair and good. Yeah.
So we'll try that. Yeah, whatever the conclusion of the order, literally the words that are in
Right,
the
that's
order.
Exactly, yeah.
Right.
Yeah,
From conclusion down to your signature.
Yeah.
although we don't
I mean,
generally,
some of them are longer than others, but still.
I mean, whether you're granting or denying it?
I don't know, my proposal is to put in whatever is the conclusion of the order. Uh-huh. Yes.
right, so we've got a case
So there's no
on,
ambiguity, we're not saying anything that isn't in the order. I think that's the best way to go.
right, in one of the
That's what the
cases,
board wants.
case number 5, we just have a one sentence conclusion, then the board accepts, the board also does this, boom.
Yeah, okay.
That's not really any additional place for
Right.
you.
Right, exactly.
Any other comments on the minutes? So we're tabling it anyway. Ms. Paulson is going to give her executive report.
So I passed out a copy of the BSA resolution. The board, you may remember, had voted to support DOB's application to revoke the certificate of occupancy for 255 18th Street, and the BSA had actually voted in favor of that, but we've now gotten a written decision, so I give that to all of you. In terms of the amendments to the Loft law, they are still pending. The legislature comes back next week. We'll see what happens. The unofficial revenue for January 2019 was $35,079. And I've given you a copy of the latest milestone statistics. I do want to note that there was a transcription in October. So in that last category where it says total buildings with C of O, the October one had the opposite of what's there now. It had 25 and 10, but actually it should be 10 that have a C of O without a pending removal application, and 25 that have a C of O with a pending removal application. And that's all I have to say.
Thank you, Ms. Mickelson.
Oh, no, I have one more thing to say, sorry. The project guidelines are due on Monday, and I believe...
Project guideline comments, right?
Comments, yes. comments on the project highlights are due on Monday, and I think Ms. Moskowitz had sent out an email to all of the board members. So if you do have any comments, if you could get them to her as soon as possible so that she can put together one document that comes from the board to DOB. Yes.
Yes. Although
Do you have a deadline for that?
it's due on the 25th, I think, unless it was extended again.
Not yet.
So I'm planning to turn that in. I know Heather, the other architect on the board, is working on that as well, and anyone else who wants
Who wants to send it to you, right? And your deadline for those comments is the 25th.
Right. And I guess there's a possibility if you don't want to go through me,
It's not,
you could
are your, when are your comments due back?
Oh, right, it's not to DOB until the 28th.
Yes, right. The 20th or the 1st or something like that, 28th.
28th.
Your comments are due back to DOB on the 28th, correct? Your compilation.
I thought it was the 25th,
No.
but 28th?
I think it was
It's
the last day.
It's the end of the month,
Last day
yeah.
of the month,
Last day of the
Okay.
month. And if I'm wrong, I'll get it extended to the 28th. Don't worry.
So part of the idea was to get this
Just
stuff.
to get it earlier. For you
So
to
that you have
send.
time to actually look at everything and wrap it all up in the 25th and the 28th.
Correct. So your deadline for comments to you is not when it's due to DOB, it's for DOB the 28th.
Okay.
Yeah.
So that makes sense then anyway, the 25th internally, if we want
Yes,
to
right.
Yeah.
email the 28th, and we just send it to you.
No, it goes to.
Oh, it goes back to, we'll get you the,
Jason Woods. I
Jason
think.
Woods, yeah. Are
Okay.
you on that?
Just on the email
Yeah,
with them.
Right, exactly.
Do what?
Jason Woods, that's the person that sends
The
it out.
project, the
so-
person who's managing it, the team that's managing it.
But we'll get you the
Thank you.
contact information.
And thanks for doing that, sponsor. It's a lot of work. Okay, yes,
At last month's meeting, you reported on an upcoming city council oversight hearing. And I believe the date has shifted yet again, so perhaps we could update the board members.
March 4th at 2 p.m.
Thank
That's the new date. Thank you for bringing
thank
that
you,
up.
appreciate that, that's important.
Isn't it March 4th?
March 4th,
Yeah.
Monday, March 4th.
Monday, March 4th at 2 p.m.
And I presume you folks will be
Yes.
presenting.
Well, the department will be testifying as well as the exec director.
The department.
DOB.
Do you-
Got it, okay.
Yeah, just to clarify, the Loft Board is its own entity inside of the department buildings for administration. So, I'm referring to the department buildings. Yeah. We're good? All right, there are two cases on, I'm sorry, is there any other comments? There are two cases on the appeals and reconsideration calendar. The first case is 99 Sutton LLC. Address is 99 through 111 Sutton Street, Brooklyn. The docket number is AD0096, and Mr. Bobbitt will present this case.
Thank you. On August 12, 2015, owner filed an application seeking removal from the Loft Board's jurisdiction. After an investigation, an informal conference with owner, and the submission of additional documents by owner, the board denied the removal application. In order number 4656, issued on March 16, 2017, the board found the application was premature because the certificate of occupancy did not accurately reflect the configuration of the building, including the IMD spaces. Owner twice subdivided IMD units without notifying the Loft Board as required by the Loft Board's rules. Furthermore, owner did not have a DOB permit for the second subdivision of the units. In addition, the board rejected the 38 alleged sales agreements because agreements contained irregularities. These irregularities included, but were not limited to, inadequate proof that the agreements reflected sales and not security deposits, and that the filings were incomplete. The board also found that the owner did not timely file the 38 sales record forms and agreements and imposed civil penalties totaling $152,000. On April 27, 2017, owner requested reconsideration of the portion of order number 4656 that rejected the sales agreements and imposed the fines. On September 17, 2017, the board granted the reconsideration to the extent that order number 4656 rejected the sales record forms and agreements and imposed fines for late filings. The portion of order number 4656 rejecting the removal application remained in full force and effect. The board granted owner another opportunity to provide different and additional information to support its claims that the sales record forms represented valid sales of rights and instructed staff to issue an administrative determination as to the validity of the sales filings. On November 2nd, 2017, owner submitted additional evidence to augment its previous sales filings. On March 28, 2018, after reviewing all of the previously submitted documents and owner's additional submission, staff issued an administrative determination reiterating that the filings did not support findings of valid Article 7C sales and that the filings contained irregularities and were incomplete. Staff noted that some payments were or appeared to be security deposit refunds. The language of the agreements was vague to demonstrate that tenants knowingly sold their rights and improvements, and the tenants who allegedly sold their rights were not occupants of the units at the time of the sales. Staff also reiterated that the filings were incomplete because the sales record forms were unsigned and owners' efforts to locate the prior tenants to get their signatures were unreasonable. However, staff accepted owner's contention that rejection of a sale of rights allows an owner to file a second sale of rights because the prior sale was invalid. Staff also accepted as true that owner member Joe Torres was not the Jose Torres who occupied Unit 402 and who allegedly sold his rights to owner for $1. On May 9, 2018, owner filed an appeal application. Pursuant to 29 RCNY 107.1, little d, in deciding an appeal for an administrative determination, the board considers whether the facts found are supported by substantial evidence in the record, whether the law was correctly applied, and whether the penalty imposed is appropriate. The proposed order finds that the facts found were supported by substantial evidence and the law was correctly applied. However, the order rescinds the imposition of the penalties. In the appeal, owner first alleges that staff crafted a new set of objections as to why the sales agreement should be rejected. However, in order number 4656, the board rejected the filings due to irregularities and incompleteness. In the reconsideration request, owner asserted the board did not give enough specifics to inform owner as to why some of the filings were rejected. Therefore, the determination points out in great detail all these irregularities. These include inadequate consideration, incomplete, missing, or deficient sales agreements for all units, vague and confusing emails in support of owner's claim that it made efforts to locate tenants, and lack of occupancy of tenants at the time of the alleged sales. Owner next alleges the determination is a post hoc rationalization, citing several cases. However, for the reasons stated in the proposed order, the cases owner cites are easily distinguishable. Owner next argues that occupants do not have to be tenants at the time a sale takes place because Loft Board rules allow for sales after tenants have vacated. As explained in the proposed order, owner is wrong. Both the law and the rules state that a seller must be a residential occupant. The fact that rules allow an owner to document a prior sale at a time after the occupant has moved does not give owner the authority to purchase rights from an occupant after the occupant has moved. Nor does the statutory scheme for abandonment provide a rationale for purchase after an occupant vacates, because here the owner is not asking for an abandonment fine. The proposed order also concludes that owner has not made reasonable efforts to contact former occupants to complete the sales paperwork. Here, owner did a minimum amount of searching with poor results. Where owner did make contact, there was no follow-through. As the proposed order notes, in one case, owner submitted an unsigned but notarized affidavit in which the controller swears the office manager sent one email to the tenant on an unspecified date and received no response. Documentation such as this does not demonstrate reasonable effort to contact the former occupant. Next, the proposed order concludes, as did order number 4656, and the determination that the sales agreements were confusing and misleading and do not support sales of rents. While there is no magic language that must be included in the sales agreement, a valid Article 7C sale must include evidence demonstrating that a tenant voluntarily and intentionally relinquished the sales right. Here, the sales agreements never mention the loft law, and the agreements state the landlord's payment covers the sale of tenant's property, fixtures, rights, claims for security deposits, last month's rents, and other fees and credits related to the unit. The proposed order finds this language insufficient to support a sale. Next, owner argues staff should not have considered misrepresentations made 18 years ago and that there were no prior findings of false statements or filings. However, as the determination correctly found, order number 4656 noted owner's principals misstated their roles when they originally filed for coverage and that some of the so-called sales payments were security deposit refunds. Furthermore, the proposed order notes that owner twice subdivided IMD space without notifying the loft board as required, and for the second subdivision, did not even secure a DOB permit. These actions alone call owner's credibility into question. For its last argument, owner argues that the board and staff review was, in owner's words, a complete canard in that the board and staff never intended to give any weight or consideration to the documentation owner submitted. However, in the determination, staff agreed with owner's position that a rejection of a sale of rights allows an owner to file a second sale of rights. Staff also accepted the statement of owner's principal that Jose Torres, who occupied Unit 402, is not the same person as owner's principal, Joe Torres. As to penalties, the proposed order recommends that an owner should not be penalized for filing late if the board rejects the filings. Therefore, the board rescinds the imposition of the $152,000 in penalties.
Is there a motion to accept this case? Mr. Bauer, second. Mr. Hernandez. Mr. Rivera.
Mr. Cover.
Yes.
I'm sorry. Comments on this case?
Yeah, I would just like to comment that this is the third time I think this case has come to the board. First in a legalization case where we denied legalization, then in a reconsideration, and now reviewing the administrative determination. This is a very serious situation, and the fact that an owner could register 31 units with the loft board and then get a C of O for 48 and then units, and then present us with 64 residential units, all of which had sale of 28612 record sales forms, is something that needs to be, and I believe is being looked at in a number of different venues. And I plan, and let's face it, if the owner paid the fines, $150,000 would be 1/10 of the revenue that the loft board collected in 2018. So that the board feels it makes sense to say we can't fine you for not timely filing a valid document because the documents you filed were invalid does seem to make some sense. But I hope the board continues to keep a very close eye on this building, and I plan to vote yes.
Thank you, Mr. Delaney. Is there any other comment? And then do we have Ms. Rivera, could you please?
Mr. Cover.
Yes.
Mr. Barrett.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Schechter.
Yes.
Ms. Torres. Chairperson Johnson.
Yes.
7 in favor, 2 absent.
Thank you.
We did make one small language change that did not get,
No,
Yes, we did. Hold on. He read it, actually.
I think you're right.
Okay, so we changed the, on the very last page, just above where the big B is, where the sentence starts, moreover. Moreover, I'm sorry, that's the wrong decision. Okay. On page 10 of 11, under penalties, in the second sentence in that paragraph. The Loft Board finds an owner should not be penalized for filing late if the board rejects the filings. That's the change.
Thank you. The second case is Wang and Associates at address 145 Grant Street, amended number R0366, and Mr. Clark will present this case.
Thank you, Chairperson Hamilton and board members. On March 11, 2014, tenants of 2 units applied for coverage for their units in protected occupant status. Owner did not file a timely answer and served owner with a notice of default. After the administrative law judge denied owner's untimely motion to vacate its default, the ALJ conducted an inquest and issued a report and recommendation. On February 22, 2017, prior to the Loft Board issuing an order, owner registered the building, the units, and tenants. On May 16, 2017, the Loft Board staff assigned the building an IMD registration number. On April 19, 2018, the Loft Board issued order number 4764, dismissing the application for coverage and protected occupant status as moot due to owner's registration, listing the units and tenants. On May 29, 2018, owner filed a reconsideration application. Owner seeks reconsideration based on 3 grounds: error of law, denial of due process, a material fraud in the underlying proceeding. Owner argues it was an error of law to dismiss tenants' protected occupancy claims as moot based on owner's registration because the registration does not constitute an admission of tenants' protected occupant status. However, it has long been the Loft Board's practice to consider the tenants listed on the IMD registration as protected occupants of the units in which they reside. Owner argues that there was a denial of due process and that material fraud occurred in the underlying proceeding. However, the Loft Board's order dismissing tenants' application was not based on anything related to the application or the inquest. The order was based on owner's registration. Therefore, owner's allegations of denial of due process and material fraud in the underlying proceeding should be rejected by the board. The proposed order before you denies the application for reconsideration.
Is there a motion to accept this case? Mr. Delaney, is there a second? Mr. Hernandez. Is there comments on this case?
Yes, I have some comments. I believe the analysis as drafted is incorrect. I believe the owner is correct that the registration form requires that every occupant be listed, but the form does not say that the owner is agreeing to confer any particular legal status on the occupant who is listed. And it's on that basis that I'll be voting no.
Mr. Carver, thank you. Any other comments? Is there, then we should please call the board members.
Mr. Carver?
No.
Mr. Barber?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
yes.
Mr. Shachter?
Yes.
Ms. Torres?
Yes.
Chairperson Hickson?
Yeah.
6 in favor, 1 against, 1 absent, 2 absent.
There are 2 cases. Thank you, Mr. There are 2 cases on the summer calendar. They're voted on as a group. The cases are Pamela and Christopher Brown at 255 18th Street in Brooklyn, and that docket number is TA0230. And then tenants of 255 18th Street, at 255 18th Street in Brooklyn, that docket number is TM0091. Do we have a motion to accept these cases? Mr. Hernandez? Second, Mr. Chak. Any comments on these cases?
Yes, I'm going to vote no on both of these cases. I know they're on the summary calendar, but again, the notion that we have a stipulation that we neither accept nor reject, that includes, in case number 3, the tenant withdrawing a diminution services claim with regard to an elevator and agreeing not to file a further application for the lesser of 5 years from the date of the execution of the stipulation of the issuance of a final rent order, unless either of the tenants suffers a permanent, significantly debilitating injury or condition, just strikes me as something out of a different century. And I don't think we should be accepting these, even though we turn a blind eye to the kind of stuff that's going on.
Okay. Is there any other comments? Mr. Rivera, could you please poll the board members?
Mr. Carpenter?
Yes.
Mr. Barber?
No.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Chaka?
Yes.
Ms. Torres?
No.
Chairperson Hudson?
Yes.
4 in favor, 3 against, 2 absent.
Okay, the motion is not passed.
Not to be difficult, but didn't we recently,
We have 9.
what? We have 9 members, right? Okay, so therefore, if all special interest groups you can pass with 4 requires only having 8 members.
Yes,
Yeah, okay.
well, we have 9.
There are 3 cases on the master calendar. The first case is tenants of 47 Thames Street at 47 Thames Street in Brooklyn, and that docket number is CC0001, and Ms. Paulson will present this case.
This case is a tenant challenge to an owner's registration of a building and some units as IMDs. In 2006, owner brought several ejectment actions against some of the tenants in the building. In response, tenants alleged they were subject to rent stabilization under the Emergency Tenant Protection Act, or ETPA. After the Loft Law was amended in 2010, and while those court actions were pending, tenants filed a coverage application with the Loft Board, but asked the Loft Board to hold the application in abeyance until the litigation was concluded, and the staff of the Loft Board complied. On February 28, 2018, the litigation concluded when the Appellate Division's Second Department found that the tenants were subject to the protection of the Rent Stabilization Law and Code, and in support of that statement, the court cited to sections 281.5 and 286.2i of the Loft Law, and a case granting coverage under the Loft Law. On June 27, 2018, owner filed its registration. Tenants then filed an answer asking the Loft Board to reject the registration. Tenants claim they are regulated tenants under the ETPA and not the Loft Law. Tenants first argue that the Loft Board should reject the registration because the building has a certificate of occupancy and previously had a temporary certificate of occupancy. However, pursuant to the Loft Board's rules, the issuance of a C of O only bars registration if the C of O was issued prior to the effective date of the law. Here, the C of O was issued 1 year after the effective date of the 2010 amendments to the law. The issuance of a temporary C of O will only bar registration if the temporary C of O is in effect on the effective date of the law and remains in effect thereafter. Here, the temporary C of O lapsed well before the effective date of the law. Tenants next argue that the registration is not timely because it was filed after the deadline for acceptance of new registrations contained in MDL 282A subdivision 1 of the multiple dwelling law. Tenants state that the registration cannot relate back to the filing of their coverage application in terms of timeliness However, the Loft Board's rules state that a unit may be deemed an IMD if it was included in a coverage application filed by a residential occupant on or before March 14, 2013, or if the landlord is directed to file a registration by a court of competent jurisdiction pursuant to a pleading filed prior to March 14, 2014. Here, tenants filed their application for coverage on June 21, 2011. Therefore, the proposed order rejects this argument. Tenants last argued that the 2018 Appellate Division decision held that the units and the building are subject to rent stabilization under the ETPA and not the Loft Law, because that was the central dispute in the underlying litigation. However, the record in the court proceedings below contained numerous references to coverage under the Loft Law, and the Appellate Division cited to the Loft Law and the Loft Law coverage case in support of its decision. Therefore, it is more likely the court was stating the building was subject to rent regulation under the Loft Law. For these reasons, the proposed order rejects tenants' claims and accepts the registration. The proposed order also dismisses the tenant's coverage application as moot.
Is there a motion to accept this case? Mr. Carver, is there a second? Mr. Barrow.
Former chair is calling Mr. Elliott. Who is? Lamont.
Any comments on this case? No? Okay, so Mr. Rivera, could you please poll the board members?
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shackler?
Yes.
Ms. Torres?
Yes.
Chuck Colton?
Yes.
7 in favor, 2 absent.
Thank you. The second case on the master calendar is Marcus Hoffman at 255 18th Street in Brooklyn, docket number TA0231, and Ms. Development presents this case.
Board members. On December 28, 2016, Marcus Huffman of Unit 201 filed a rent dispute application. Owner failed to file an answer within 30 days of service of the application, and on February 27, 2017, the oath judge issued a notice of default to owners. On March 9, 2017, owner moved to vacate the default. The judge granted the owner's motion and scheduled a settlement conference on April 17, 2017. Tenant did not appear for the April 17th conference. The judge then scheduled a final trial date for June 6, 2017. Both tenant and owner appeared on the trial date, where tenant then moved to withdraw his application without prejudice. Owner objected. Although tenant made his motion to withdraw on the first day of trial, the record showed that there was no pretrial motion practice, the tenant never requested an adjournment, the parties did not engage in discovery, and the owner did not spend considerable resources to defend the claims. The proposed order before you accepts Judge Garcia's report and recommendation that the tenant's motion be withdrawn without prejudice.
Is there, do we have any questions for this case? Motion to accept this case, I'm sorry, I'm getting, Mr. Delaney. Second, Mr. Hernandez. Okay, any questions on this case? Comments? Then, Mr. Rivera, can you please call the board members?
Mr. Carver?
No.
Mr. Barber?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shackler?
Yes.
Ms. Torres?
Yes.
Chuck Henson?
Yes.
6 in favor, 1 against, 2 absent.
Thank you, Mr. Rivera. The last case on the last calendar is being tabled. Therefore, that is the end of the cases today. Board members, we could do a half an hour brew. I should have asked Mr. Barrows. Mr. Barrows, would you like to do that? Mr. Delaney.
Yeah, you're about to bring down the curtain. Yeah, before you
For
do,
lack of a better word.
We have a meeting scheduled on March 6th. Can I ask what we're planning to do with that meeting?
Well, since we're not discussing rules today, we will follow up on the protected occupancy rule and the discussion with the attorneys.
But not with fresh language in front of us.
Do you want, well, I'm not sure what you want, so we can draft something if you'd like. I thought, what I thought was that we would talk about it today and then we could present you with fresh language. So I'm a little concerned about redrafting if I don't know what you want. So I'm more than willing to give you a fresh draft to work off of if that's what you'd like.
Well,
But I'm not 100% sure what it should say.
well, that's, and given our agreement that there was a 2
2
week
weeks,
period,
right,
that's
correct.
kind of, and I thought today we were going to discuss, go back to the other rules, not protected occupants. So,
Oh, okay,
so therefore, we're going to meet on March 6th.
right.
And so I can prepare correctly, we think, will be a general discussion of protected occupants.
I think it should be, because I really want to talk about what was said and your view of what was said while it's still as fresh as possible in your minds. So I think it's important to do that sooner rather than later and put the other stuff to the side for now, unless
Okay.
the board disagrees. But, I mean, why have them in and then wait 6 weeks until you talk about it?
Well, it seems like we, at the last meeting, managed to beat the extension rule to death, and that's done. So I thought if we were going to spend time today, which I'm fine not doing, we would have probably started with an narrative statement conference. But March 6th, we're going to devote to protected occupants.
Yes,
Okay. Without new language.
yes, because we
Right.
have to figure out what to draft.
Fine.
I have a question. I like to always be in attendance, but I teach on Wednesdays and this meeting's happening on a Wednesday, so I can't leave my students. I'm wondering if I can submit a written piece or how can
Absolutely.
I participate?
Absolutely, and I do apologize for that. The only reason that it's going to be on a Wednesday is that we could not find space on a Thursday. DOB is doing a lot of construction in their buildings, and it's very difficult for us to actually find a location. So our wonderful office manager, Irma Rivera, reserves these rooms for the meetings very far in advance, years in advance. So, but to add additional meetings, it's hard. So I do apologize for that, and we will try very hard never to do that again. But yes, of course, submit stuff.
Bring your students.
Government in action.
So that's going to be here?
Yes.
Yeah.
Any other comments before we close? This will conclude our February 21st, 2019 Loft Board meeting. Our next public meeting will be held, as we just discussed, on Wednesday, March 6th at 1 p.m. Right here at 22 Ridge Street, Spectre Hall. Board members, please sign in and hand in your attendance.